and I'm glad to get the opportunity to raise this issue and speak on this situation in relation to the redress. I clearly remember the first woman that confided in me about her time in a mother and baby institution. It was about 10 years ago. I was a member of Kilkenny Borough Council at the time, and this lady actually had come to me for advice on a different matter, but she ended up telling me her story in relation to her time in a mother and baby institution. I still remember her sadness when she told me her story, partly as so few in her life knew about it, and it has always stayed with me to this day, and I always felt very glad that she felt she could share her story with me. Since that time, I've had the privilege of meeting and speaking with so many women who were forced into mother and baby institutions. Also, many children who obviously now are in their adulthood who had been born into one of the institutions. Some have found their children or mother, but so many are still looking and still holding out hope, sometimes up to 50 years later, that they will be reunited. On many occasions within this chamber and throughout debates on this issue, I have heard people refer to this period as being a dark time in our history. And I have to say, I've always struggled with this description, as while it certainly was a dark time, and there's no disputing that, I think that trying to confine it completely to history dismisses the serious intergenerational trauma felt today still by so many. And while the state continues to deny justice to both women sent to these state-run institutions and the children born there, it remains, I believe, very much part of our present. In 2007, I was 25 when I had my first son, Emmett. I was not married at this time, and I do think if it had been 1967 or 1977 or even 1987, would I have found myself in a mother and baby institution? Would Emmett even have been taken away from me? And I have to say, I find this really difficult to even think about. I remember how incredibly nerve-wracking the whole labour and birth process were, and I had great support and encouragement by my side. I had great medical help, and in particular from the midwife. I always remember actually the midwife stayed past her shift to stay with me. And what exactly must this have been like for women alone, scared, terrified in fact, met not only with little or no medical help, but no encouragement or kindness or support or even a reassuring smile. And tonight, as we discuss this, I am thinking of the woman I met who at 15 was raped. She did not know what pregnancy was or what was happening to her body. I'm thinking about the woman who had a partner when she discovered she was pregnant. They planned to get married, but she was taken away late one evening. She was told she was going on a drive to visit a relative, and then she was driven to Besborough. Her son was taken from her when he was born a few months later. I'm thinking about the woman who told me she tried desperately to get her baby back from the nuns. Eventually, she was told he had been adopted to a county that was very far away from where she was located in the southeast. 30 years later, when she tracked her child down, it turned out that this story had been total lies. In fact, her son had spent the first 8 months of his life less than a mile from her home. I'm thinking about the man I met in his 60s who spent decades looking for his mother. Thankfully, he did find her, but he only had 2 meetings with her before she passed away. When he eventually received his file after she had passed his way, it was filled with countless letters begging to know where her son was. And I'm thinking of the woman that is still looking for her daughter, born 42 years ago in Besborough, and so many others. Now imagine, after all of that, to learn that you might be excluded from the scheme because the institution that you were sent to is not included. Or you only spent the first 3 months of your life there, not the first 6 months. Imagine you are left with certain medical conditions as a result of your time in one of the institutions, but you were only there for 5 months and not 6 months, so you don't qualify for the enhanced medical card. And I know a number of women who are actually left incontinent due to the circumstance of their childbirth, and actually were left traumatised and were unable to form significant relationships going forward because of their kind of embarrassment and shame on that issue. And we shouldn't have to, they shouldn't have to come and tell us such personal stories, but they do. But she didn't spend 6 months in an institution, so she won't be entitled to the enhanced medical card. And another lady who spent 5 months and 20 days, to be exact, in an institution, who actually nearly lost her leg due to sepsis brought on by the horrific treatment during her labour. Again, she falls outside the criteria. Imagine you were boarded out or nursed out, treated like a slave, in many of these situations physically and sexually abused, but you don't qualify for the scheme. There is no price that can be put on any of this, but what the state can do is listen to survivors and their families. Look at the Oak Report, commissioned by you, Minister, and use that as a starting point. People engaged with this process in good faith, again reliving their stories, which was not easy, and now it seems again it was for nothing. Nobody should be excluded from the scheme. It should cover 100% of survivors. The religious institutions and the pharmaceutical companies also need to be held to account for their role in this. They often profited at the expense of children and women, and they must also pay. Survivors and their families are tired of apologies with no action. I do understand, Minister, that you are not the person responsible for the Commission of Investigation, and in fact, you inherited this from predecessors who I believe were happy to kick it down the road to your door. However, you are now in a position where you can, for the first time on behalf of the state, ensure the right thing is done, that survivors are actually listened to and their wishes respected. And you can ensure that nobody is left out of this scheme. I fully believe that you would have the support of each and every one of the TDs here in the Dáil to do this. And I also think that this 33rd Dáil must finally be the Dáil that ensures that justice is done by every single woman and child that had to pass through those horrific institutions. Garmagat.
Thanks. Last count, Corla. Minister, I tried over the last few days to think of new words that will somehow crack through the state's deep-seated denial and awful treatment of the mother and baby home survivors. Women, girls and children who suffered horrific abuse and human rights violations in these religious prisons. One in my own constituency of Meath West, the Castlepollard Mother and Baby Home. I don't have words strong enough to split the state's cruel and coercent attitude of disrespect towards survivors. It is an attitude beyond any language, I know. It stands in stark contrast to the human dignity of the survivors and their families. These women have been to hell and back. If it wasn't for their courage and bravery, the shameful legacy of the mother and baby homes would have remained shrouded in secrecy, swept under the carpet. There would have been no commission of investigation, no state apology, no redress scheme. The survivors had to push the state every inch of this torturous journey. They had to chip away at a wall of silence. The redress scheme published last week is an insult to the survivors. It is an extension of the flood of disrespect that these women and their families have waded through for decades. It is shameful that the government has brought forward a scheme that creates a hierarchy of victims by taking the view that some mothers and their children suffered less than others. It is cruel to deny compensation and medical supports to some survivors simply because they were taken from their mother or left the institution before 6 months. Not only is it callous, it flies in the face of modern clinical evidence regarding the traumatic impact of forced separation on babies of that age. The idea that it didn't affect them because they were under 6 months is not only morally repugnant, it is also nonsense in a scientific sense. It is wrong that the Minister would seek to justify this botched scheme in this way. This needs to be rectified. No matter how long you spent in these places, no matter what age you were when you left, you suffered greatly and you carry the trauma and the pain with you to this day. And religious institutions are responsible for that pain and trauma too, and they must contribute to the scheme. The state cannot allow them to wipe their hands. The timing of the scheme is also disrespectful. The Minister announced the scheme in full knowledge that in the very same week survivors were in the High Court challenging the report of the Commission. The report on whose recommendation the scheme is based. Recommendations which survivors described as whitewashing of their abuse, especially the contention that no forced separation took place. This scheme continues the disrespect demonstrated in attempts to seal survivors' records, in the leaking of the Commission's report to the media before survivors had a chance to see it, in the destroying of survivors' evidence given to the Commission. What is so fundamentally wrong with this state in 2021 that it would seek to prolong rather than help ease the trauma of these women? This exposes again the deep and the dark psyche of a state that puts its claustrophobic interest above those citizens brutalised in its name. Women, girls, children who cry out for justice, for dignity, for basic humanity, and a state that pushes back against those cries at each and every turn. Minister, survivors don't want this botched report. They want an equal scheme in which everyone's hurt and trauma is recognised. They are not willing to leave behind anyone who spent a single breathing moment incarcerated in those wretched places. That is an integrity, a strength and a compassion to which we should all aspire. Ireland would be a better place if we did. Minister, listen to the survivors, finally listen to them. Deliver a scheme that matches the gravity of their experiences, a scheme that is fair, just and equal for all. Thank you.
Minister, the redress scheme needs to be reviewed as a matter of urgency and proper consultation with organisations representing survivors of institutions which oversaw the forced separation of mothers and babies needs to take place immediately. Like all those affected need to be treated equally and fairly, regardless of age when separated, whether they were boarded out or what institution they were in, or indeed how long they spent there. I mean, the state has failed women and it has failed the children who were forcibly removed from their mother. It doesn't matter what age the person was when they were actually removed from their family. It has had an impact on them. So for this redress scheme to exclude children under 6 months of age is inequitable. I've heard from many of the survivors of these institutions, including the ones named under the scheme and those indeed that aren't, and their stories are heartbreaking. And again, it doesn't matter what age they were. They've been very much affected throughout their lives. Many survivors will tell you that they may have been adopted by a perfectly lovely family who gave them a good upbringing, but does not take away the different feelings of separation, sense of loss, the feeling of not being wanted or not knowing who they are or why they were adopted. And there has been research that would indicate that children of less than 6 months in age are affected by separation, and indeed only people who've been adopted can understand the concept of not having a sense of belonging or knowing exactly who they are. I cannot understand why children who were boarded out are not included in this redress scheme. Many of those children were nothing short of slaves and were often terribly treated. It was common for farming families to have a boy or a number of boys on the farm to work, and while some may have been treated fairly well, many were not, and once they reached the age of 14 left this country forever, and who would blame them? Like, they felt unwanted then and they feel unwanted now after they've been ignored again. So there is a need to include everyone in this scheme, no matter what age they were or what institution they were in. Religious orders and pharmaceutical companies need to finance the redress scheme, or at least contribute to it. Substantive recourse from these bodies needs to be sought immediately, in fact insisted on immediately. Thank you.
Well, I'm not a good last count caller. Minister, as you know, I'm a member of the Children's Disability Equality and Integration Committee, and we heard at that committee the heartbreaking testimonies from those affected by the mother and baby homes. And the last time I spoke on this, I read testimonies of survivors that they made to the Commission of Investigation, and I'm going to give it again tonight, Minister, because it's important to hear these women's voices. One woman spoke about the conditions her mother endured while giving birth. My mother was tied to the bed, and when she couldn't push, one of the nuns sat on her chest to make her. On the immoral and evil practice of forced adoption, one person stated, "My son was wrenched from my breast by one of the nuns while I was feeding him and taken away for adoption. At no time did I give my consent to my son's adoption." Another mother spoke about the death of her child. I do not even know whether he was buried in a coffin. There was never even a kind or sympathetic word said to me. The psychological impact on mothers has been enormous. This mother said, the nuns at Bessborough made my life hell and changed my life forever. I could not get over what happened to me. I think I'm still in shock and traumatised. My time at Bessborough was a horrific, horrible experience, and I think I will die with pain and trauma that this has caused me during this time. Minister, the reality is, if any of these survivors, and any of these survivors and these testimonies that I read out, spent less than 6 months in a mother and baby institution, they would not be eligible for the full redress. Minister, this has to be changed for a whole myriad of reasons. These stories are horrific. They're actually harrowing and heartbreaking. It's emotional even reading them out on behalf of these women. And these women and children were abused by the state already. Minister, let's not abuse them again. Good.
Too little and too late best describes the state response to the suffering of its citizens in these institutions. We were far too late in stopping the practices in these mother and baby homes. We were far too late when we set up the Commission of Investigation, the final report of which was best described by my party colleague as a miscarriage of truth. And it has been too little in terms of the amount of redress and the number of people proposed included in the scheme. This government, your government, has failed at every turn when it comes to the survivors of these penal-like institutions, and now they will be failed again. Why must it always be like this? I'll reference a different case, sexual abuse in day schools. I explained to various education ministers over the years the case of sexual abuse in such a school, Crelane in Limerick. At the time, those ministers seemed upset and promised to act. However, the failure to act led me to believe that any fair solution they had were torpedoed by officials in their department. Minister, I asked the same question. Did the same happen to yourself? When Louise O'Keefe won her case in Europe, it took years for the survivors to be included in redress. These brave men at Crelane School had to protest in Brussels and at the gates of the Dáil here to achieve fairness. Will the survivors in the mother and baby home need to do the same? I hope to God they don't. At every point in the mother and baby home process, the government have imposed obstacles to survivors. The final report underplayed the actions of those institutions. These women were interned and their children were kidnapped. That is a stark reality of what actually happened. And now we expect to accept that there will be a hierarchy of survivors. We are expected to accept that those boarded out children are to be excluded. We are expected to accept a redress scheme that is based on a Commission report that is itself extremely flawed. Well, it can't be accepted, and it won't be accepted by the survivors I've spoken to. What can be accepted is a commitment to remove the time-based redress criteria, a commitment that those who were boarded out will be included in the scheme. What can be accepted is fairness for all survivors. The responsibility and the shame is with those organisations that ran those homes of hardship. TDs from all parties read the accounts from the survivors last year. Many of us were emotional when we spoke about the horrendous wrongs that were done to the women and children in those homes. I appeal to those on the government benches to be sympathetic to the needs of all the survivors, support this motion, and together we can at the very least ease some of their pain in this.
Throughout my discussions with you all the time, Minister, you've always seemed to genuinely care about the survivors and want to do the right thing by them, and I won't deny that. But unfortunately at this stage, it seems as if you're being prevented by your colleagues, Fianna Fáil and Fine Gael in government, from doing the right thing here. And they have a desperate track record on this issue. They're stuck up to their nicks, and make no mistake about it. And it's not just them, because it's the religious institutions, it's the embassies, the justice system. They were all responsible for keeping these hellholes open and putting families through what happened. And now we're effectively talking about human trafficking here, and I've said it here in this House before. Yet a 6-month exclusion now has been put in and been drawn by the government, which denies 41% of people that were in these from getting redress. Let's make no mistake, these homes and institutions were a money-making machine for an awful lot of people down through the decades. And now we're denying families and individuals. And I said it to you here the other day, most of them, all they want is recognition. But we're even denying them that. It was brought up already about children that were boarded out. They must be included, Minister. And there must be more consultation with the religious orders. They have a responsibility, and the pharmaceutical companies have a responsibility in these issues. Women who went through these institutions, those like him, like Sean Ross, like the county homes in Thurles and in Cashel, my own constituency. The survivors, they deserve to be heard. They deserve to be listened to at this stage. I'm asking you, Minister, to do the right thing here, to actually review the whole thing immediately, the redress scheme, because it isn't wanted. It's not making the survivors happy even. It's just adding more hurt on top of hurt, what has gone on for decades. So I'm asking you to, I hate saying it, to stand up to the Fianna Fáil Fine Gaels that were stuck up to their nicks in it down through the decades. But that seems to be the only way that the survivors will get actually what they deserve at this stage. So I'm pleading with you on behalf of the survivors that have been contacting me and everyone here in this House to actually do the right thing by survivors at this stage.
Corla, and I welcome the opportunity to address the issues raised in this motion this evening. We're all united in our belief that the state must take responsibility for the indisputable wrongs that were visited on women and children who spent time in these institutions. As the Taoiseach stated in his apology earlier this year, the state failed you, the mothers and the children in these homes. It would be difficult to find a family in Ireland whose lives the legacy of mother and baby institutions have not touched. It weighs heavily on individuals and it weighs heavily on us as a country. Since coming into office, I've met with many survivors. I've listened to their stories, and I know that for each survivor of these institutions, the experience has had a unique and had a deeply personal impact on them. There are no easy answers when it comes to trying to remedy the huge grief and anguish that survivors have experienced. And I know there is no sum of money and no action that can adequately atone for the vast harm, for the lasting trauma, for the impact of mother and baby institutions and the impact that they've had on each individual who passed through their doors. And my engagement has also shown that redress for survivors is a broad concept. What I've found throughout the last 18 months is that government is an imperfect vehicle for restitution of past wrongs. It can move slowly, often out of necessity to deliberate, but at a time when those who are affected have already waited for far too long. When the Commission's report was published in January, I made it clear that this work was a priority for the government. In the 11 months since, we've advanced legislation to allow for exhumation at Tuam. We've introduced draft legislation to allow for access to birth and early life information, and we've opened the Commission's archive to survivors. Throughout all of this, I've sought to work constructively with deputies and senators from all sides. Previously, I've accepted private members' bills where the intention of that legislation reflected the government's own, and I've worked with the Joint Oireachtas Committee on Children to progress legislation. Given the sensitivity of these issues, I aim to seek consensus over division and to allow for these issues to be fully debated. It's on this basis that the government will not oppose the motion brought forward by Sinn Féin and supported by some other parties this evening. We will be bringing forward legislation in the new year to support the establishment of a payment scheme, and during that time, deputies will have the opportunity to bring forward specific proposals, their specific views in relation to that scheme. In January of this year, when the Commission's report was published, there was significant criticism within this House and outside of the categories suggested to be eligible for payment within that report. Although not part of the terms of reference, the Commission's recommended the following 3 categories for consideration: people who were resident as an unaccompanied child in a mother and baby or county institution, pregnant women who entered mother and baby or county institutions before 1974 and who spent 6 months in such institutions, women who undertook commercial work without pay in county homes, in the Tuam mother and baby home, and outside a mother and baby institution where they were resident. If a 6-month residency by the Commission, it's estimated that 6,500 people would have been eligible for a financial payment, and the cost of providing this payment and the enhanced medical card would have been €400 million. Concerns about the use of those criteria were a central theme in the debates that we've had in this House and in many of the parliamentary questions that deputies have submitted to me. The interdepartmental group, the group that was established to bring proposals on the scheme to government, it made broader recommendations. It recommended that all those who spent more than 6 months in an institution as mothers or children would qualify for a financial payment and for an enhanced medical card. This would have increased the number of eligible for benefits under the scheme to 19,000 individuals and would have cost €673 million. However, in the decision the government took last week, the government went significantly further. Having considered the IDG report, having noted the feedback from the consultation process, the Government has brought forward a scheme which will provide financial payments to an estimated 34,000 people and enhanced medical cards to an estimated 19,000. And the value of this scheme will be €800 million. It will be the largest scheme of its kind in the history of the state in terms of the number of beneficiaries. And in bringing forward this scheme, the Government is responding to the concerns about the categories that have been raised since the Commission's report. It will include all mothers, including those who entered an institution after 1974 and who spent any period of time in one of these institutions. It will also include children, both unaccompanied and accompanied, who spent 6 months or more in an institution. And this expansion recognises that a strong case was made that there is little distinction in reality between being an unaccompanied or an accompanied child in one of these institutions. For children who spend short periods of time in an institution during their infancy, and recognising the diverse understanding of redress, the Government's action plan provides a response to their needs in the Birth Information and Tracing Bill. The legislation will provide guaranteed access to an unredacted birth cert, as well as wider birth and early life information for those who have questions in relation to their origins. And this is the overwhelming priority need which has been expressed by people who as children were adopted or otherwise separated from their birth family. It's also important to emphasise that for all survivors, all former residents of mother and baby and county home institutions, counselling support is available under the National Counselling Scheme. It's free of charge, it includes out-of-hours support, and survivors are entitled to priority access. Through the consultation process, survivors made it very clear that they want a scheme that's non-adversarial, simple, and is based on trust. Survivors did not want a scheme that would require evidence of the harm done to them, and the requirement for a low burden of proof was also a key issue raised. And this is what the Mother and Baby Institution Payment Scheme seeks to deliver. It was concluded that providing a general payment based on time spent, with no requirement to bring forward any evidence of abuse or harm, was the best way to ensure that this scheme causes no further trauma or harm. And the simplicity of the scheme will also allow it to be established and for payments to be made more quickly. In terms of next steps, I want to confirm that I will be seeking significant contributions from the relevant religious congregations towards the cost of the scheme. I initially wrote to the religious authorities involved in the operation of the relevant institutions in January when the Commission's report was published. When bringing proposals for this scheme to Cabinet, I contacted them again, signalling I intended to bring forward this scheme imminently and seeking a meeting to discuss their contribution to the cost of the scheme. And I am due to meet several of the congregations in the coming weeks. And beyond the matter of the congregation's contribution, I want to assure survivors that everything will be done in our power to get the scheme up and running swiftly, and that the scheme will be designed so the applications from older and vulnerable survivors will be prioritised. Due to the magnitude of the scheme, legislation is required for it, and my officials are preparing a general scheme of a bill as a matter of urgency, and I've confirmed with my Cabinet colleagues that I will look for priority drafting of the bill when it comes to government. The Mother and Baby Payment Scheme, providing 34,000 survivors with financial payments and 19,000 survivors with an enhanced medical card, is just one element of the Government's comprehensive response to the legacy of mother and baby institutions. I've already spoken of the legislation to allow for the remains in Tuam to be exhumed, identified and reburied, of the birth information and tracing legislation giving a legal right to an unredacted birth cert, and of access to the Commission's archive, which has already been taken up by almost 300 survivors. We're also progressing commitments on the National Memorial and Record Centre, which will appropriately memorialise and inform on Ireland's history of institutional abuse. We're progressing health research with former residents, the introduction of the history of this period into the secondary curriculum through the NCCA, research scholarships on childhood disadvantage, and an examination of the terminology and language we use when discussing these issues. All 22 actions, each which represent a particular facet of the state's response, each of which represents elements of the state's redress to individual survivors and to survivors as a group continue to be advanced by my department and across government. I'd like to conclude by thanking deputies for their contributions to this debate. And most importantly, I again want to pay tribute to the resilience, the courage, the engagement and the patience of survivors, their families and advocates. As a government, we will continue to work at responding to the legacy of mother and baby institutions. Thank you, Laskin Corley.
Now back to Sinn Féin, and there are 1, 2, 3, 4, 5 speakers, beginning with Seachta Daly.
Thank you. Minister, I want to tell you about 2 boys from Kerry, James and Michael. They were left to the mercy of this state and suffered a horrendous childhood. They were boarded out from the county home in Killarney, County Kerry, when James was 8.5 and Michael was 7. The state had a duty of care to these little children, but sent them to work in servitude and enforced labour. You're here to work, they were told. The shameful story is of James and Michael Shukru. They were sent to a house which had no lighting, no heating, they weren't properly fed, and having authorised their boarding out, there was no adequate inspections provided by the state. James, who's now 70, told me again today he was physically and sexually abused over many years. He was failed by the social workers that were supposed to protect him, and when his education finished, his school and his council declined him a grant for further education on the basis that there would be no additional benefit to him. James went to Hammersmith and later made a life for himself in London and has suffered from post-traumatic stress disorder. Michael was not so fortunate. Growing up, he'd been beaten many, many times, stripped and beaten in public with a stick on one occasion. He suffered with addiction and mental health and was found dead alone in Crystal Palace in 1993. This left a void in James's life which can never be replaced. Later in life, compounding this injustice, James was forgotten by every redress scheme. He was not recognised, he was denied a full Garda investigation. At every hand's turn, the state told him there is nothing we can do. Why, Minister, having listened to James, are you continuing to ignore him? Offering counselling to a man at this stage of his life, he says, is an insult. Give them the comfort of redress, please. For once in this state, let them be included. Or are you going to be like Michael's neighbour who said to James after his funeral, I'm sorry about your brother. We heard his screams, but we did nothing. That's the only apology that they have ever received.
Minister, I do welcome the very fact that government are not going to oppose this tonight. Look, you've heard statements from speakers in here tonight, and it's true, and we've all known people that have been directly affected by it, and obviously, Minister, you've been in direct touch with them. But when you listen to witness statements and saying how they breastfed their child while facing a wall, and to have that child torn from their breast and taken nearly 45 years to see him, you tell me it's not traumatic. It's been mentioned already here, the state, the church, pharmaceuticals, the legal profession, undertakers. We're not finished with this at all yet, Minister. I mean, and people are coming forward all the time. But I would urge I suppose ask for the utmost urgency in trying to get some kind of redress, but the advanced or the enhanced medical cards, from a lot of people I've been speaking to, the survivors are very anxious to get them because they're getting old and they're getting frail. The cost of dental work and other medical procedures is extremely expensive, and they're only looking for a bit of quality of life. They've gone through their suffering. They're going through the pain now. Yes, a lot of them wanted to tell their stories, just to tell their stories. They weren't looking for a pat on the back, but they needed to offload. But we're here again, and I was thinking when I was listening to the rest of the speakers a while ago, and I was going, geez, my God, I said, this is probably we've had many dark times in our history. But this one we should be really, really ashamed of, because we left our own people down. We left mothers, children, grandparents. And if we can't stand up today and admit, look, it was certainly a collective thing. They were all in it together. They should be all in it together to sort it out. And we have a responsibility in that. So I'd ask for urgency on it. Cormac and Margaret. Thank you. Let's go, Gorla.
Margaret, let's come forward. The facts have been laid bare to the nation about the scandal of the mother and baby's homes. The survivors had to fight every inch of the way to even be heard, let alone be recognised. Now they face another botched scheme, and with no disrespect intended. It was designed, no doubt, by people who never had anyone belonging to them in these institutions, or known anyone who endured the hardships they suffered. It is in this context the people of Ireland that are outraged at the latest attempt to bring forward a much flawed and diluted mother and baby institutions payment scheme. A scheme that will leave hundreds of survivors from obtaining enhanced medical cards because the period spent was less than 6 months. A scheme that, for all intent and purposes, created a hierarchy of suffering and pain, differentiating and categorising each survivor as if one person's pain and suffering was not the same as anyone who stepped over these notorious thresholds. A scheme that excluded innocent children, especially those who were boarded out and those who spent less than 6 months in these cold, oppressive and callous institutions, about 60% in total. This scheme must be redesigned, Minister, and we must as a nation do far more for those survivors of these oppressive, inhuman institutions who treat their mothers and babies like chattel. We are calling on the Government now to listen to the ordinary, decent people who want this sorted out in a dignified and honourable way. And speaking of honour, it will be remiss of us not to mention Catherine Corliss and her relentless fortitude in her search for justice for the babies and mothers who perished in Tuam. The Taoiseach in his apology said, "The shame is not theirs but ours. It was our shame we did not show them the respect and compassion which we as a country owe them." Then let us do exactly that and rethink, redesign and change the scheme for the memory of all the lost babies and all the survivors of the mothers and babies' homes. Let us do this in the spirit of a nation that really cares and cherishes all the children of the nation equally.
Minister, I suppose the question that everybody across the state wants to know is, why have your government decided that there should be a hierarchy on suffering? That's the question. Who made that decision? Children who were boarded out, many of them used as slaves, many abused, they've been excluded, along with children in these who are less than 6 months in these appalling institutions. They're excluded, and a number of homes and institutions and all of the survivors who spend time in them, they've all been excluded. And that means that they can't access the enhanced medical card or the financial redress. But it's much, much worse than that, Minister. It means that the state doesn't actually recognise what happened to them. That's the biggest insult of all. The scheme has created an appalling hierarchy of victims and a clumsy hierarchy of suffering that does not reflect the experiences that survivors have had. And yet you say you listen to survivors. It needs to be rectified immediately, Minister, before more hurt and trauma is inflicted by the state on survivors. And let's remember, the state is responsible for the harm that was done, and it must take responsibility for that. The time limits that exclude survivors has to be removed. The institutions and children who were boarded out must be included. The religious orders and the pharmaceutical companies must also step up and take responsibility for what they did. And the government, I know you've said you've been in negotiations with them, but you have to ensure that that happens. I would say to you that all of these abuses have lifelong effects on people. And survivors, you know, at this stage, after all this time that has passed, they're still being excluded. There was one opportunity to address it, Minister. It has to be addressed. Let the government do the right thing in the name of God after decades of campaigning for redress and justice. Just this once, surprise us and do the right thing by these people who are let down by the state.
Minister, it is impossible to calculate the trauma experienced by those who are resident in many of the mother and baby homes across the country. To understand the emotional, psychological and physical distress the survivors still experience to this day is something that can only be comprehended by those who lived through this awful experience. We can only attempt to grasp their suffering by listening to their testimonies, and it is clear from the many stories these survivors tell that they still manifest each and every day the pain of their traumatic past. Each and every day, these survivors face new challenges, and as they get older, they face the additional challenges of declining health, retirement, or losing a spouse. And these may negatively impact for many on their already fragile psychological state. Many show evidence of post-traumatic symptoms, and while their experience may not necessarily have prevented their ability to adapt to daily life, it is certain that for many that to continue living a normal life as best as possible, they would have to repress a lot of these traumatic memories to focus on building a life. For others, the trauma and stress of their experience have left a permanent mark, which has continued to influence their lives. The government could have resolved this matter because it is the right thing to do. Taoiseach Micheál Martin stated recently in the Dáil that not everybody will be satisfied with the entirety of the redress scheme. The Taoiseach needs to understand that it is not just a matter of whether someone is satisfied or not with the proposed scheme, but that the scheme is causing unnecessary distress to survivors. It is in fact re-traumatising those survivors excluded from the scheme and will only continue the pain and hurt these survivors have felt all of their lives. The government needs to look again at this flawed scheme and ensure that no survivor is excluded. Thank you.
Just before moving on to Labour, Deputy Function, did you formally move the motion? If you could just formally move. Ag bugger I inis Portia and looked over. I shocked the batch.
I welcome the opportunity to debate this motion so ably proposed by Deputy Function, and my Labour colleagues and I were happy to co-sign it to render it truly a cross-party motion. And Minister, just to welcome your announcement that the government wouldn't be opposing it. I think that's a really welcome and welcome approach to take, and indeed look forward to further constructive engagement on the legislation that will be introduced in the new year that you've described to form the basis for the scheme. I think this is a genuine attempt to work to strengthen and improve the redress scheme, and I know that it is appropriate. I think that's what survivors would want, that we would all work on a cross-party and collaborative basis. Many of us have received emails and contacts from survivors and their families who have eloquently conveyed their feelings and experiences, and indeed we've all heard the very powerful voices of survivors. And just to pay tribute to the incredible women like Catherine Corliss, former Taoiseach, to Joan Burton, Christine Buckley, Rose and late Christine Buckley, Rose and Mags McKinney, Susan Lohan, Anna O'Mara, Samantha Long, and all those who used their voices so bravely in pursuing justice and who've spoken out about the injustices that they've experienced. So we owe them this approach, this collaborative approach, to ensure that their trauma doesn't become a political football, and that we can move forward in a non-adversarial fashion on this. And I do want to first just express my own sympathies, as well as those of my Labour colleagues, to all those who experienced suffering and distress in the Mother and Baby County and Bethany homes. Looking at the report, since January when it was published, the report of the Commission has certainly generated an intense debate, and a debate that's been both painful and indeed cathartic for survivors as well as for our society more generally. And indeed it's built on the reports on other shameful institutional practices in our state, like the Ryan Commission report, like the Murphy report, like so many of these reports that exposed the abuses to which women and children in particular were exposed in so many institutions over a relatively short history. Our history of institutional abuse indeed is horrific. We have incarcerated people, women and children in particular, for far too long, and the witness evidence in the report really exposed the violations of human rights of so many. We know that a total of 56,000 mothers and 57,000 children passed through the institutions in the decades examined. Thousands more were resident in other institutions outside the terms of remit of the Commission. A shocking mortality rate for infants was exposed in the report. 9,000 infants and babies in the homes covered by the report died before their first birthday. As I say, a really shocking rate of 15%, or 1 in 7. And within the confidential committee section in particular, we learned of the true extent of abuse suffered by survivors, physical and psychological. Also the widespread practice of forced labour and the extensive practice of coerced or forced adoption. So I think we're all conscious that, as you've acknowledged, Minister, there can be no quantification on the distress and trauma caused, and it's very difficult to place a price, indeed probably impossible to place any sort of price on what is owed to survivors by the state, religious orders and all those complicit, including of course pharmaceutical companies, and I do want to refer to that. In my previous life as a barrister, I had the privilege of representing survivors of abuse before the residential institutions redress boards. So I have experience of working within one of those redress schemes. First, I learned from so many the terrible harms they had suffered at those institutions, but I also witnessed the flaws that were in that system. And I think we've clearly learnt from that scheme. It essentially institutionalised a hierarchy of suffering in that it required survivors to provide evidence of harm and abuse suffered in institutions and in order to achieve a certain level of compensation. And it was a very difficult, very traumatic process to appear before the board for those survivors who did so. Many of them told me they felt it was pitting survivors against each other, so that was a really re-traumatising impact. And I think having seen that in effect, and it was obviously devised with the best of intentions, and yet we see therefore how difficult it is to develop an effective, a robust compensation scheme. And I think learning from that, there are many aspects of this redress scheme that are very welcome and that clearly are a great improvement. The scale of the scheme is hugely welcome. 34,000 survivors eligible for financial payments, 19,000 for an enhanced medical card. It is to be non-adversarial, that's very welcome. It is to be accessible, and there's no requirement to submit evidence of abuse or harm caused. And again, I think that's really welcome. There's no requirement of silence, as I understand, and that again is very welcome because that was a really unfortunate facet of the previous scheme. So those are all the welcome aspects. But of course, there are also critiques that have been expressed in recent days, and I think they're very valid ones, because there are still a number of people who will be excluded. While it's great that women survivors who live abroad will qualify, as well as those who spent less than 6 months in the institutions, we still see a distinction where children who spent less than 6 months will be ineligible for payment, as will children who were boarded out unless they spent their first 6 months in an institution. And of course, we've seen excluded from the enhanced medical card scheme women who spent less than 6 months in an institution. And that's really regrettable, particularly as many of those women will have arrived at the institutions in late stages of pregnancy. And we have heard from many who did suffer physical harm, medical harm as a result of incarceration. And indeed, back on 26th February of this year, this Dáil Éireann passed an amendment from my colleague, Labour Deputy Sean Sherlock, to give an entitlement to a medical card for all former residents of mother and baby in county homes. And I would ask, Minister, that you would consider giving effect to this amendment, to that intention of the Dáil as expressed following a very constructive debate that day. And indeed, that's something that others have also sought, and it's called for in the motion. Many survivors have also expressed concern about the timeline for redress and concerns that if the scheme doesn't open until late 2022, payments may not be expected until 2023. And I would ask, Minister, that you might examine the feasibility of a programme of interim payments to survivors, such as in the North. I know you've said you will prioritise older and vulnerable survivors, but there is that other mechanism of an interim payment scheme that might well meet some needs of survivors. I do also want to just address the point you raised in your own speech as to who pays for the scheme and the role of the religious orders. And we know, of course, that the executive summary of the Commission's report was widely criticised for spreading blame perhaps too broadly beyond state and church and saying responsibility rests mainly with fathers and immediate families. And I think we do need to re-emphasise the causative role of both state and church authorities. We know how powerful the church was for so many of the decades in which these institutions prevailed. And we know that the church was also, through its ethical and moral and teaching of dogma, was directly responsible for generating the moral context in which shame and secrecy prevailed for so many who were incarcerated in the homes. We know that not until Labour's Frank Cluskey introduced what was called then the Unmarried Mothers Allowance in 1973 did the state take any responsibility for women who had been so shamefully neglected for so many decades, and not until 1987 did we finally pass laws to abolish the status of illegitimacy. So state and church bear huge responsibility for the suffering of women in these institutions, and indeed not just the Catholic Church, but we know also Protestant churches which had a role in incarceration. And we know also that there was obstructiveness displayed by some of the orders involved during the compilation of the report, and that has certainly been made public. So we do need to see, therefore, a much greater role for religious orders in bearing financial cost of redress. And again, just to refer to the residential institution redress scheme and how the well-known failure of church and religious orders there to pay what was their fair share of redress, leaving the state to bear the disproportionate cost of the scheme, and the reasons for that have been well aired in this House and elsewhere. So we in Labour have called for religious institutions to make a fair and proportionate contribution to this redress, and I know, Minister, you've stated your intention that they would do so. If they don't, then we've committed to drafting legislation to compel them to make a contribution. I hope it won't come to that, because I do think, again, we've learned from the experiences of the past. And I do think we also need to look at the role of private capital in the system of abuse. In Chapter 34 of the Commission's report, the issue of vaccine trials was discussed in great detail, and it's really disappointing to learn that pharmaceutical companies do not, which were involved in those trials, do not see it apparently as necessary to make a financial contribution. And again, I would ask, Minister, that we might look again at that. And we must also acknowledge, of course, that there are many other measures that are crucial for survivors. The Adoption Information and Tracing Bill that our committee is currently reviewing, and of course what we think should be done, a comprehensive review of adoption practices in this country to ensure that we are dealing truly with the legacy of the past, that we're looking at issues around illegal adoptions in particular, and looking at these issues of forced and coerced adoptions, and indeed falsified birth certificates. So we need, Minister, to work constructively with you, and we certainly intend to do so, to ensure the strengthening of this redress scheme, but also that these other measures that are so sorely needed by survivors are also put in place. And I look forward to doing so, and I'm glad that we'll see no vote on the motion, which has cross-party support.
Social Democrats, Holly Cairns.
Every time I stand up in this House to talk about mother and baby homes, I feel the weight of it. It's always hard to know where to begin when talking about something that has caused generations of trauma for so many people. It's difficult to convey the hurt, the bewilderment, and the sheer rage that no one is actually being held accountable for these crimes, and it doesn't look like anyone ever will be. The scale of what went on in these institutions is staggering, horrifying. Forced adoptions, falsified records, vaccine trials, medical experiments, missing children, mass graves, the forced separation of families, the casual obliteration of histories. Survivors deserve justice, the public are behind them, and the government still isn't listening. Despite what the Minister claims, this clearly is not a survivor-centred scheme, nor is it based on transitional justice. The headline-grabbing figures, I think, might have looked impressive at first glance, but the real story lies in the details. Time limits, signing away of litigation rights, and disregarding very many survivors' trauma. Regrettably, none of this is inspiring or surprising. After all, this government resisted attempts to give survivors access to their personal records, continues to deny GDPR, and refused to extend the Commission investigation to allow for greater accountability. All of this compounds the abuse suffered by thousands of individuals and their families from the state-administered and church-run system that incarcerated single and unmarried mothers, victims of rape and children. The redress scheme needs considerable reform. If the Minister is sincere about his intention to listen to survivors, then he needs to start acting like it. I'm going to use my time to highlight some of the deficiencies of the scheme, but there are many others that I won't have time to address. The government needs to listen to the survivor groups, not to a deeply inadequate Commission's report, and not to attempts by the Department to limit the rights of survivors. The main defect is the highly insulting requirement for individuals to have spent 6 months as a child in a mother and baby institution. Forced family separation is one of the worst human rights violations. The state and religious orders intentionally separated mothers and babies, stigmatised them, and denied them means to find each other. This is a lived and very real trauma which is obviously not bound by a minimum time in an institution. Someone born in a mother and baby home could have spent a week in there, but a lifetime searching for their family. Under this scheme, they are not entitled to redress. Survivors have expressed their devastation at the cruel stipulation. Clinicians and medics have shown that the 6-month requisite has no basis in evidence and shows no understanding of trauma. The letter to the Minister from over 30 experts states that childhood trauma has the greatest impact early in childhood, They point out there is no threshold of time linked to this, and as a result, I'm quoting this directly, having an arbitrary period of 6 months exposure is simply that, arbitrary. This arbitrary time restriction needs to go, Minister. Any and all children who are subjected to this cruel system deserve acknowledgement and redress. That is the absolute bare minimum. The second issue relates to the provision that those who received redress in respective time in mother and baby homes under the Residential Institutions Redress Scheme cannot access this scheme. This limitation is symptomatic of no understanding of trauma and a pervasive civil servant mindset that is more concerned with balance sheets than justice. I'm going to quote directly from the government's proposal to give you a sense of the cold, unsympathetic language used. The intention is to prevent double counting by making a second payment in respect of the same institutional experience. In other words, how dare you seek more redress? Why can't you be happy with the little you were given? This language is condescending and paternalistic, and it makes another appearance in the third matter I want to raise, which is the legal waiver. If you're a survivor of a mother and baby home and you want to avail of this scheme, you must sign away your rights to take this matter to court. In essence, the government is proposing a legal gagging order on survivors. In other words, take the official apology and as little as €5,000 and sign away your right to any legal recourse. Not only is this deeply troubling in principle, the proposed scheme's language reveals the patronising attitude of the government. They acknowledge that applicants, and I quote again, may be disappointed at the inclusion of a waiver in the scheme, and some may interpret it as representing a failure to take responsibility or be truly accountable, but this is not the case. Why? Because the Taoiseach apologised. In other words, sign away your rights and be happy with an inadequate apology. The government goes on to explain how survivors should accept redress as it will spare them burdensome court procedures and the risk of incurring high legal fees. It doesn't take a legal expert to read between the lines here. If you do not sign the waiver, your other option will be an adversarial court case because the state will oppose you. The government seems to have no appreciation for the anger among survivors and the general public. People are simply not going to stand for this redress scheme. Not only is there a complete lack of understanding and empathy for survivors, but no lessons have been learned, for example, from the ongoing mass rejection of the cervical check scheme. The same will happen with this redress unless major deficiencies are rectified. Survivors will rightly reject it, and they will be supported by society. Limitations, caveats, waivers were found in previous redress schemes for survivors of institutional and clerical abuse, for the survivors of Magdalen laundries. The difference now is that we will not stand for it. In the past week, we've gotten a sense of the anger and the frustration at this scheme. The opposition to the flawed elements will only increase when it comes to the legislation. If the Minister is not going to make the necessary changes because it's the right thing to do, perhaps he will do in response to the waves of public pressure that are on the way. We saw it last year with the public outcry concerning the archive of the Mother and Baby Homes Commission. Society has changed. People are incredibly angry at the abuses perpetuated by this state and religious organisations. Furthermore, they are shocked at the treatment of survivors, and this anger will not abate. The next issue is the Minister's reference to the Birth Information and Tracing Bill as part of the government's response. During the pre-legislative scrutiny of the bill, we have heard from survivor groups, human rights advocates and experts, and data rights experts who have pointed out the multiple issues with the legislation. It places barriers to access birth records, it limits early life and care information, and it denies siblings and other relatives access. The legislation needs significant changes if it is to come anywhere near what the Minister is claiming it does. Finally, where is the accountability? Ultimately, nobody is being held to account for the worst abuses perpetuated by this state against its citizens, against vulnerable young women, people with special needs, victims of rape and incest, members of ethnic minorities? Why are existing laws against incarceration, forced labour or human trafficking not being applied? Why is there one rule for church and state and one rule for everybody else? Why hasn't the coroner investigated the unnatural deaths that occurred in these institutions? We know there are mass graves. We know there was crimes that occurred. And instead of responding, seeking justice and accountability, the government's burials bill is actually limiting the powers of the coroner to investigate. You couldn't make it up. Disgracefully, the outline of the scheme informs us that the Minister has written to the religious congregations seeking to, and I quote, meet with them in order to discuss how they might contribute to the scheme. To discuss how they might contribute. This is cap in hand stuff. It's 2021, not 1950. Where are the demands for justice? Where are the attempts to seize the proceeds of illegalities? These orders profited from these systems. Not only did they receive state payments, they participated in forced labour, human trafficking, and the sale of babies for money. Many of the people who committed these heinous crimes are now deceased, but not all of them, and the orders still have assets from the money made off the backs of young mothers, children, and babies. Where is the scheme to seize them for survivors? I don't have the time to raise the other deficiencies, such as the overall inadequacies of the financial amounts and the limiting of the scheme to only certain institutions, but these will also need to be addressed. While the scheme in its current form has many insulting and callous flaws, it is not a done deal. The government still has time to do the right thing and put in place a scheme that is actually survivor-centred and based on transitional justice. There is still time to do the right thing by survivors.
Thank you, Deputy.
But know that if you do not, survivors will not stand for it, and neither will any of us.
Thank you, Deputy. I'll turn next to the People Before Profit Solidarity Group. And Deputy Boyd Barrett, do you wish to move your amendment?
Yeah, I do. But first of all, I want to thank Sinn Féin and the other signatories of the motion, and I want to say that we agree with everything that is in their motion, and thank them for bringing it forward. And in fact, it's only just become apparent to me that the amendments we put in were purely additions. They weren't meant to, and we never delete their motion. So I just want to make that clear. That's been added in by the Bills Office. We sent in additions with a couple of changes, but nothing substantial. They were all additions to what was in, because we agree with everything in the main motion. I just want to make that clear. And hopefully although the idea was that there shouldn't be a choice between the two, and the Bills Office have done it that way, and I don't really understand why. Anyway, I'll set that aside, because the more important thing is the message that gets across to the government on this. And look, Minister, you're going to have to revisit this. I'm just telling you now, you're going to have to revisit it. Arbitrary time periods or tables of compensation linked to time periods are offensive. And they completely fail to take into account the reality of coerced, forced separation of mothers from children. Okay? Though the trauma, the suffering, the impact, the lifelong consequences, the varying consequences, which are unique to every single case, cannot be, and there should be no attempt, it is offensive to try and link them to arbitrary time periods in an institution or to a table linked to time periods with amounts of money linked to that table. Just think about it, Minister. It's shocking, okay? And you're going to have to revisit it. And I cannot believe that survivors, and certainly any survivor I've talked to, and as someone who myself was born in a mother and baby home, where I don't even know how long I was in 2 mother and baby homes, in fact, from what I understand, how long I was in them, and I'm sure a lot of people don't know. But the impact could be horrendous if you were one day it could be somewhat lesser if you were 6 months, depending on the outcome. But in every case, the primal wound of children being separated from their mothers and mothers being separated from the children is a crime that was committed by the church and state against mothers and children, tens and tens of thousands of them. So to create arbitrary thresholds that you reach where the state considers you worthy of redress is absolutely offensive. Now, I know you didn't mean to be offensive, Minister, but the problem is the state and the church, this whole sorry saga, is about the crimes of a church and of state against mothers and children, but then trying to cover their back, trying to limit the damage. And then you end up compounding the hurt, the insult, the abuse and the trauma that were perpetrated against mothers and children, and re-traumatising the victims. It's obnoxious. I know you didn't mean to be obnoxious, but that is the net result. And it compounds what was done with the report, where the testimonies of the survivors were essentially relegated to being relatively unimportant. Okay? Whether it was intended or was just gross mistake, I don't know, but it was wrong. And one of the things we've added into our motion is to say that report must be fully repudiated. Fully repudiated in terms of its conclusions. Some of the stuff that was in that report was offensive, Minister. Right? I'm just telling you it was offensive. There's no point in saying it wasn't, because it was. And some of what's in this scheme is offensive. I don't believe it was deliberate, but I do believe it smacks of the state covering itself, trying to limit things instead of trying to do right by the survivors and the victims of this whole horrible scandal. Okay? And we have to walk in lockstep with the people who are at the centre of this. The mothers and the children and the survivors, we have to walk in lockstep with them if we're going to get this right, and this has not done it. So I ask you to review it, and to review it in consultation with the survivors. The other thing we've added in is about if the church institutions do not, and the pharmaceutical companies do not, pay their fair share, and they have a lot of assets in terms of funding redress, they have to be forced to do it. Right? They have to be forced to do it. And we should be saying that absolutely clearly. Their assets will be expropriated if they do not do it. I mean, for God's sake, I don't know what they're doing running our hospitals and schools anymore, half these institutions. But the idea that we're going to ask them nicely, they have to be told, and if they're not going to do it, they have to be forced. There's other individual details I won't bother. They're in the amendments that we've put, but the point has already been made by Deputy Kearns and other people that what you're saying about those who are not included in this scheme, that they will have in the tracing bill and so on, guaranteed access to all their identity records and birth certs, it's just not true, is what people have looked at it closely, and as I see it, it is not true, right? So we need to address that. The other changes we've put in, I've only a few more seconds, is just to say sometimes it's forcible separation. In fact, it's always forcible, but the way in which it's forced can be coercion or force. It can be unlawful technically or lawful technically, but it's all wrong, right? It's all wrong. And to create a hierarchy and distinctions that don't understand that human reality of it is wrong, and you need to revisit it, Minister.
Thank you. And Deputy, it's been clarified to me that your text is additional as opposed to a replacement.
It's additional.
That's what I've been given to
Okay.
understand.
So there's a game of divide and conquer being played here, and I believe that it is entirely deliberate. There are 58,000 survivors of mother and baby homes in this state. The redress scheme will provide financial compensation for 34,000 of them. Thousands will receive no compensation whatsoever. These include the children who were boarded out, all those who left the homes before attaining the age of 6 months. That's divide and conquer that's being played out here. And that's what the survivors believe, the ones that I've spoken to, and I've spoken to many. More than 30 experts in childhood trauma wrote to you saying that these provisions ignore best practice guidelines in neuroscience, childhood trauma, attachment. They make a telling point. They say the earlier the impact of trauma, the more long-lasting the effects. I think that rather spectacularly undermines your crude 6-month cut-off rule. Rosie Rogers, the survivor of Castle Pollard, put it very well. She pointed to the divisiveness of your policy when she said, anything after 6 months and you are acknowledged, anything less and your pain doesn't count. Everybody who has spent a day in this institution, it has left its mark. There is no inclusiveness in this redress. Nor is the compensation adequate for the 34,000. Furthermore, forcing people to wait until 2023 to receive payment is unfair. Many of the survivors are, of course, elderly. In Northern Ireland, there are interim payments being made. Why is that not happening here? Minister, I want to say a few brief words about your role and the role of the Green Party in all of this. Many people voted Green in general election 2020, and in doing so, they voted for change in many cases. They wanted something different. They bought the idea that the Greens were radical. But what they see here is the old politics, including, as I say, an attempt to divide and conquer with people who are victims of oppression. Those people can't see any difference, I believe, now between Fianna Fáil and Fine Gael. And I think they have a very strong point. I'll leave it at that.
Thank you, Deputy. We'll turn now to the regional group and Deputy Sean Canning.
Ministers, I suppose, first of all, I want to thank Sinn Féin for putting forward the motion, and I supported the motion, and I put my name to the motion on the basis that, as I think I said to you last week, Minister, the idea of dividing people has come across very badly with survivors. I've spoken to a number of survivors in the last week in relation to the redress scheme, and they're disappointed because they all came into this together. They all told their stories together. They all bared their souls in public and in private to tell people what had happened to them. And they didn't do it for any other reason other than they wanted to get, first of all, an apology from the state. And the second thing they were looking for was recognition for what they had gone through. And as one of the survivors said to me, you know, Sean, the first 6 months weren't grand, and then it turned after that. One day in one of these homes could have caused somebody as much trauma, as much anguish, and leaves as a big a mark as somebody there for 5 years or 6 years. So that's why I think that the idea of segregating people, categorising people, and dividing them has created a resistance to the redress scheme. And I know that it was well intended, it is well intended, this redress scheme. But I also take a different view when you talk about the cost of the scheme, because I don't believe the state should look at the cost as much as look at what it has cost in human terms to those people who are in these homes, the mothers and the babies, and the lives that they have led in the meantime, and how they've carried this burden for years, and how they've carried the anguish with them. And whether there were a month, a day, a week, or 6 years, the anguish and the pain is still there. And sometimes when we try to do something like this, to do something good, we sometimes get it wrong. And I would say, Minister, this whole redress scheme needs to be re-examined. We should not try and divide and segregate people. I think it's also important to realise that people, as somebody said earlier, people are getting older. The survivors are getting older. And a lot of the survivors have told me over the last 5-6 years is that this is not about money. This is about recognition and for the state to say, yes, I will try and do something for you. But when you say, I'll try and do something for you, but I won't be able to do anything for you because you weren't long enough there. How do we have to serve an apprenticeship, they've asked me, before they qualified? This is something that I think we have to look at and say, no, this is not what it's all about at all. This is about real, genuine people who have suffered more than enough. And I think even for us talking about it here, we're talking about events in the past and we're not proud of them. But we have to stop talking about it and we have to get the action done. We've got to give people what they require. They have placed their faith in the modern politics, the modern politicians, the politicians of today, to make sure that they get what they are deserving. And as politicians, and I think the motion has been accepted by yourself, Minister, but I think you have to go beyond that. It's not just accepting the motion and not opposing it. I think we need to see this redress scheme taken and broken apart, and as I say, put back together in conjunction with all the survivors and the advocacy groups, so that we create something that is going to be fitting for what we're dealing with. And it's something major in people's lives. And as Deputy Barrett spoke there about it, you know, the passion is there. It's not a political thing. It's about everybody trying to do the right thing. And I think that's why we're here talking about it tonight, and that's why the motion is here. I would also take this opportunity to say that as politicians, you know, we come across some things that we say that's not right. But one of the survivors, I was talking to him on Saturday, and he was saying, you know, Sean, he said that he was lucky. He was fostered out to a good family and a good home. And there are great stories there as well. So much so that he farmed the land for 40, 50 years, and then he was left the farm. But when it came to giving him over the land, he had to pay stamp duty at 7.5% because he was a foster child, as opposed to paying stamp duty at 1% if he was the son of the child. That's what he said. Sean, he said, we're being victimised everywhere we go. It's a family that were handing their son, despite the paperwork, the family farm. Even though he was fostered, it was a case that he had to pay 7.5% stamp duty. And when he tried to get it back, no, that was the rules. So I think we have to look at the rules and say, why are the rules there? They're not to victimise people, they're there to help people along. I think the other part of the motion that I think we have to look at, and it has been spoken about earlier, is to seek immediate and substantive recourse from the religious orders and the pharmaceutical companies to contribute to the state's redress scheme. I think we have to be strong on this, Minister. The reason I would say that is because the pharmaceutical companies played a part in all of this. They played a part in it, and they cannot just walk away or be let walk away. They need to own up to what they were at the time. And I've spoken to a woman who was in one of the homes in Cork lately, and she told me about, you know, after having the baby, she was given a tablet, but she didn't know what it was for or what it is. She never found out. It's not on any medical history of her. So there are things that went on, and there was experiments that were being carried out for the benefit of the pharmaceutical companies without the knowledge or the express permission of the mothers or the children. So we have to also say to the religious orders, you need to own up as well. As a TD who went to school in Tuam, I think the Mothers and Babies Home was probably closed before I started secondary school in Tuam. But I do know a lot of people who actually remember it. And they remember how children were being segregated going down to the classrooms in the schools, and they would be brought in after everybody was in the school, in the classrooms, and they would be brought out before anybody else would be let out. And one of them has said that by changing the redress scheme to having 6 months, nothing, and then after that you get something, what they're saying to me is, that's the same as when we were going to school. You were being treated differently, and now we're dividing and treating people differently. So I think we have to ensure that people, the survivors and their families, receive the recognition that they surely do deserve. They receive that state apology which we have already given, but I think it needs to be repeated many a time. And we have to show them respect, and we have to give them small restitution for what has happened to them. I don't think we can be selective, ministers. I don't think we can be. I don't believe that it would be the right thing to do. And as they've said to me, it's not about the money. And it's not about the money. It's about the people that suffered unjust experiences and probably undescribable in some cases. Finally, I would just like to acknowledge all of the work that you've been doing, ministers, but I think that this is a scheme that needs to be overhauled before it goes any further. We do not want to have any more anguish for the survivors. And I want to acknowledge all of the survivors that I have met and have written to me, and some of them have become friends, for the reason that they have done everything that they've been asked to do. They have been very polite, they've been very brave, and they have been, at times, gone through so much anguish in telling people and telling the public what actually they went through. It has been a watershed for them. I hope this redress scheme will become something that will be a watershed for this state to make sure that we do something right for these people. And finally, I would like to acknowledge the work of Catherine Corliss from my own town in Tuam, and for her family, who have gone through a huge journey with her as she has done all this work to the research to expose what was happening in Tuam. Tuam is not the only place, unfortunately. So I would say, Minister, we have an opportunity, and I would welcome your efforts in making sure the scheme is for everybody. Thank you.
I'll turn now to the Rural Independent Group and Deputy Healy-Rae.
At the outset, I want to thank Sinn Féin, and I was late to sign the motion myself, but my hat is in it as well. So, anyway, Minister, I suppose this has been a terrible time in the history of our state, and I suppose it's just 11 months since the Commission delivered its final report, and the payment scheme was finally published on Tuesday, the 16th of November, the Tuesday last. The payment involves 800 million redress plan for 34,000 survivors of mother and baby homes and county homes. However, we know from the Ministers for Children's response on the Dáil last week that an estimated 58,000 survivors of mother and baby homes are alive today. This means that the compensation scheme will not be available to 24,000 other babies and women that were in these homes. These girls, women from the outset were treated shabbily and badly from the very start. First of all, by parents, religious orders, different governments, health boards, and many babies died from neglect and not getting the medical care or interventions that would have kept them alive. Clearly, these religious orders and these modern baby homes, the money that they made was more important to them than keeping babies alive. Taken from mothers, can you imagine that? To take a baby from their mother and sold for adoption. And the new government tried sometime last year, tried to keep the records from them. He said that they were destroyed. Kept them from those trying to contact sons or daughters, or likewise sons and daughters trying to find who their real mothers were. I think it has to be a divine right that a child knows or is not impeded from getting to know who their mothers were, or indeed who their fathers were, and no arm of the state should impede them in any way from getting that information if it is available. What happened to the babies in Tuam? A mass burial in septic tanks. This is actually absolutely terrible. And I watched the programme on the RT the other night, a week ago or so. It's absolutely terrible, horrific, Minister. And you see, the government now wants survivors to sign that they're happy what the government is now offering them by way of redress, that they can't claim any further. This tells me that the government knows what they are offering is not in no way adequate. Why else would the government be trying to get survivors to sign on the dotted line like this? You're saying that unless they were resident in a mother and baby home for more than 6 months prior to being boarded out, that he won't pay the redress. Who decided that 6 months that they would have to be in a mother and baby home for 6 months or more? I've had a group of women that came to me in the last few days, and they're outraged because one of them was 4 months in Bessborough, another was 5 months, and they're being denied any redress. Minister, I'd like to meet the person that put the time limit on that, and those that were boarded out to different homes that they won't be entitled either. Minister, you're not even halfway there. He must do right and be seen to do right and to rectify what has been done very wrong, and a savage wrong has been done to these survivors. And it's very wrong to let any of these people out that were there, whatever length of time, whether it was short or much less than 6 months. I just can't understand how you think you're going to get away with this. It's not adequate, Minister, and I'm appealing to you to look at it again and ensure that all those that are presenting, all the survivors that are alive today, whether they're boys or girls, whoever, that they are seen after properly, and the way you're doing it and making them sign on the dotted line that they're happy with what they're getting, it gives me grave doubt at what you're doing, and I'm very worried about it, and I couldn't stand over it, and I'm asking you to look at it again. I'm glad to get the opportunity to talk on behalf of these misfortunes that have been treated so badly in our state by many people in our state, and it's not that long ago, and because many of them are still alive. I'm asking you please to look at it. I'm not shouting or roaring. I'm appealing to look at it fairly, because denying people that weren't in the homes for 6 months, that were in it less than that, in them homes less than that, that's very wrong, Ministers, and I'm appealing to look at it and do what's right for those survivors. Now's your time. Don't let it pass, and don't delay with it, because many of these people are on their last legs, and the medical card should be given that very important aspect should be given to each and every one of them, and to ensure that when they didn't get proper medical treatment at the time that they were being born, that at least they get for the remaining days of their lives. I'm appealing to to do that, Minister.
I'll turn now to the independent group and Deputy Catherine Connolly sharing with Thomas Pringle.
Deputy Connolly. Look, thank you for the opportunity to speak on this very important issue. I completely support Sinn Féin's motion to see an expansion of the Mother and Baby Homes Redress Scheme to all former residents of Mother and Baby Homes, no matter how long or how short their stay. And I would like to thank Deputy Kathleen Function for bringing this to the House today. I would like to echo the words of survivors group who I listened to and met outside the gates of Leinster House today, and who described the Mother and Baby Homes Redress Scheme as a travesty of justice. It truly is a travesty that those who lived or were born in these terrible institutions and spent less than 6 months there have been completely left out and excluded from claiming deserved redress. Who is this government to put a timeline on trauma? Who are they to decide at what point survivors deserve compensation for the awful conditions which they were forced to endure? It is a complete insult to those survivors who have already been failed by this state time and time again, and we really ought to be ashamed of ourselves to allow this to happen. This redress scheme is not inclusive and does not meet the needs of survivors. It is clear that there is a complete lack of survivor voice in this scheme. We cannot create a scheme without the input of the people on which it affects. This should be the heart of every redress scheme that is established and should be the priority of all schemes going forward, whatever they are for, mother and baby homes or indeed even the MICA issue. It is of the utmost importance that those affected have a large part to play in discussing the impact of the redress and that is owed to them. I understand it is a simple fact of government and politics that when attempting to provide some form of monetary redress to a portion of the public, tragedies must be quantified. My issue is that the Mother and Baby Home Redress Scheme appears to be an operation of spreadsheets and finances, with little or no evidence that survivors were at the heart of things. It seems as though a kitty was agreed upon, and from that amount the tragedies of survivors were weighed up and calculated. As I say, I understand that a certain amount of box ticking and bureaucracy must be accepted and expected in order for such schemes to operate. Subjectivity and application will not work. However, in cases such as this, the starting point should not be a final budget or monetary limit. The starting point should be and must be the survivors. If we must quantify the pain and suffering suffered by Irish citizens, pain that was sanctioned by the state on our behalf, then the Minister must listen to the survivors and base the quantification of their redress not on what has been deemed available, but based on the Government's genuine desire to offer a meaningful gesture of sorrow and remorse towards those women, children and families who it so gravely wronged. The impact of early trauma cannot be understood by anyone but those who have experienced it, and early trauma should not be overlooked. The time spent in mother and baby homes should be completely irrelevant, and the fact that anyone was forced into these institutions against their own will, separated from their babies or their mothers, should be the sole focus here. It doesn't matter for how long they were forcibly separated. The fact of the matter was that they were and wrongly so. We can't measure wrongdoings by how long they have gone on, but rather simply on whether the act in itself was wrong. The reports that have come out over the last few years regarding these institutions are truly harrowing, and it is devastating to read of the huge loss of lives in these homes. In the Northern County home in Donegal alone, 343 illegitimate children died in infancy or early childhood. Many of those who lived were subject to awful conditions and unfortunately experienced separation anxiety, PTSD and other mental health issues throughout their lives. The very least that we can do is give full and fair redress to every single one of those impacted. This is the very least that survivors deserve after all they have been forced to endure and continue to endure as well. I am calling on the Government to do the right thing here. This is a shameful chapter in our country's history. We can't bury our heads in the sand and pretend it didn't happen. We need to address this. We need to support the survivors of this. We need to give each and every one of them proper redress for the pain, the sorrow and the heartache that this state in our name has caused them. Thank you.
you very much, and I welcome the opportunity to take part. And thank you to Deputy Function for tabling the motion and also the additions put by Solidarity People Before Profit. I recognise the work you've done, Minister, to get us to this point, but I'm afraid I could go back on the history. I'm not going to in the limited time. So what I'm going to do is actually look at a number of matters. So we have the contribution or the submission from the Irish Human Rights and Equality Commission, and then with a number of observations and recommendations, and they refer to the Commission of Investigation, page 22, and it says, by the Commission of Investigation's own admissions, it did not take a human rights-based approach. This has resulted in findings and recommendations that do not reflect Ireland's human rights or equality obligations, and in turn is not an adequate mechanism for identifying the full universe of survivors. I know that you've gone a little bit beyond the mother-baby recommendations, and I acknowledge that, but not enough. And then they point out, in the past, Ireland has been criticised for its narrow interpretation of the category of persons who should qualify, and so on. And then they point out that all participants emphasised how the final report failed to recognise the gravity and magnitude of the human rights violations that occurred in mother and baby homes and the related institutions. And they reported a perceived lack of recognition. I'd go much stronger than that, but a perceived lack of recognition of the trauma of being separated from mother or child and the family destruction therein, and so on. Now, you come forward then with a scheme, and notwithstanding your best efforts, you are now perpetuating the discrimination all over again and adding to the trauma, whether you like it or not. So let's look at people other than myself and my colleagues here who have said this. What the open letter that you've got from the therapists, a bold statement from them, and they don't often do it, and I want to welcome the fact that they've done it. I think there are 30+ names, and they've spoken out. First, childhood trauma, which includes separation from primary caregiver and exposure to multiple caregivers in an institutional setting, has the greatest impact early in childhood. Time prevents me from reading it, but I do ask all of the ministers and the government to read it. Secondly, there is no quantum of time that allows us to think about the impact of childhood trauma. Thus, having an arbitrary period of 6 months exposure is simply that, arbitrary. Simply that. What is known from research in the area of childhood trauma is that it is the combination of adversity and quality of relationships which confer risk. And they go on to refer to research, and having had the privilege of working in a previous life in psychology, I can refer you to Bowlby, who we knew off as students even when we weren't paying much attention to our studies, but we still knew the importance of the bond. And that letter is outlining all of that to you. The human rights submission tells you to withdraw, asks you to withdraw the 6 months distinction. Don't have it. And yet you're persisting with that. And so I look for some idea as to where that has come from. Where has that come from? What is the justification for this? And I'm afraid, like Deputy Barry, I can't think of any other reason other than a monetary one. And so we go to this report of the Interdepartmental Group. And again, they have done some good work. But I must say it's done within a financial framework without any understanding of the trauma that has been caused by by many parts of the experience, but particularly by the mother and baby separation. An utter failure to see that, and again, a perpetuation of the abuse. And again, I want to sort of apologise if sometimes I'm too passionate about it, but I know this inside out from both a professional and a personal experience. The personal has nothing to do with my role in the Dáil, but the professional side has. And it is our duty to highlight on every occasion where this government and other governments have perpetuated the injustice and the misuse of language. For instance, I noticed that this report, the Interdepartmental report, talks about kindness and the importance of kindness. Well, certainly I would think kindness is a quality that should be inherent in a just system based on principles. They talk about the principle of kindness. Kindness is not a principle, it is a quality that should be there in any interaction with the state. But what is important are the principles of justice, proportionality, fairness and equality, and so on. That's not recognised in this interdepartmental report and what you're going to persist with. Now, on page 35, we get some idea of why the 6 months is there. And very, very clearly and quite adamantly, they tell us As outlined earlier in the chapter, the group is strongly of the view that the 6-month residency criteria is particularly important when considering children. Now, Minister, I don't know if you've read this. As it does not want, so the Interdepartmental Committee does not want to create a circumstance whereby being born in a mother and baby home or a county home is deemed a basis for the redress under the scheme. There you have it. They clearly don't want that. The mere fact that you were born in there is not going to give you any right or entitlement. And that brings home to me the utter failure to understand what we have all been guilty of in relation to mother and baby homes in Ireland, allowing it to happen. An apology was given by the Taoiseach, other apologies were given in 1999 by Bertie Ahern, and we're utterly failing to act on those apologies in a meaningful fashion. Finally, as the time is running out, there has to be a serious consideration of interim payments. These are a vulnerable group. Over 1/3 are over 70, roughly. 1/3 are between 60 and 70, and 1/3 are nearing 60. That has to be the first and foremost matter. And finally, it's just the money. I cannot escape the conclusion that is simply done on money. The exclusion is not done on principles of justice or equality, but on saving money for the state, saving money for the religious institutions and the pharmaceutical companies.
I'll return to the government and Minister Anne Rabbitte to reply.
And I would like to thank all the members of the House for their contributions here this evening. In January of this year, on behalf of the government, the state and its citizens, the Taoiseach apologised for the profound generational wrong visited upon Irish mothers and their children who ended up in mother and baby home for our county home. He stated categorically that the state did not uphold its duty of care and so failed these women and children. He acknowledged that an apology alone was not enough. It was just a first step. The government has undertaken to respond to the needs of survivors in consultation with them. As stated by Minister O'Gorman in his opening remarks, while the government strives to deliver an inclusive response, there are no easy answers when it comes to trying to provide a remedy to the significant grief and anguish caused to the women and children who spend time in these institutions. In many respects, it's not possible to replace what has been lost to survivors. No financial reward or service provision can take back the hurt, the loss and the distress that has been suffered through decades of failure. Nevertheless, the government is earnest in its wish to provide an enduring response to the priority needs of all of those concerned. The Action Plan for Survivors and Former Residents of Mother and Baby and County Home Institutions began with an apology and is broad-reaching, encompassing actions under a wide variety of themes which include a survivor-centred approach, the apology, access to personal information, archives and databases, education and research, memorialisation, restorative recognition, including health supports and financial payments, and dignified burial. While recently published work on the action plan has been underway since January to ensure that the 22 action plan points set out across the 8 themes have described are developed and implemented. The Mother and Baby Institution Payment Scheme, while hugely important and indeed the most significant scheme of its type in the history of the state, is just one element of the action plan. It has been stated that the government's intention in relation to delivering a payment scheme that is non-adversarial, simple and respectful, and that works on this scheme is already underway. I think it's important, however, to also highlight the other hugely significant elements of the action plan. These actions are not only important to government in demonstrating sincerity in addressing the wrongs of the past, but more crucially are vitally important to the survivors. Firstly, counselling to support all former residents has been in place since before the publication of the Commission's report, and the service has been strengthened with additional investment and an expanded out-of-hours support. The Government has published the General Scheme of a Birth Information and Tracing Bill. This is currently the subject of pre-legislative scrutiny and which will provide guaranteed access to birth certificates and wider birth and early life information for those who have questions in relation to their origins. It will also provide a robust statutory tracing service to support family contact and reunion. The Government is committed to advancing institutional barriers legislation to provide for a dignified and respectful treatment of remains at Tuam and elsewhere if necessary. On the same day that the Government approved proposals for the Mother and Baby Institutions Payment Scheme, it further progressed to two other important actions, both of which are intended to demonstrate Government's commitments to not just acknowledging the failings of the past, but also learning from them. The first is the creation of the Children's Fund to honour the memory of the children who died in mother and baby homes through the provision of supports to children who experience disadvantage in the present day. The second is the creation of a National Memorial and Record Centre. This action is hugely important to survivors. A scoping group chaired by the Secretary-General to the Government will develop an overarching vision and proposed approach to the creation of a national centre, which will then be brought to Government for approval. Both of these actions are tangible demonstrations of Government's determination not to forget the past and not to repeat the past. They stand as part of the gesture of acknowledgement, apology and healing to those who were failed as mothers and children. Finally, I would like to acknowledge the amendment to the motion tabled this evening. I value all contributions from the deputies on this most important of issues, but respect to the motion calls for action which would be grossly unconstitutional. The Chamber cannot nor should not seek to preempt or anticipate matters that are under the examination of the courts. The Government simply cannot support that amendment, Chair. I thank you all for your time this evening debating this important matter, and I echo the Minister's opening words of appreciation to survivors and their families as Government continues to work through these complex issues. Thank you.
Thank you, Minister. We will return now to Sinn Féin to conclude the debate, and I believe Deputy Mitchell is beginning.
Good Chair. Minister, this scheme isn't fit for purpose, and you need to go back to the drawing board. It's been widely condemned by survivors and experts, and on a human level, it dismisses their suffering. And it's basically saying that many of their experiences aren't traumatic enough to receive redress. Boarded out children and infants who spent less than 6 months in these appalling institutions are completely excluded. A group of 30 childhood experts wrote to you over the weekend explaining why this was a shocking decision. Minister, trauma can't be measured by time periods. You completely ignored the views expressed by survivors in the Oak report. That's insulting to survivors who have experienced decades of appalling treatment by this state. You created a hierarchy of victims here, and I don't believe you intended to do that, but that's the reality. The current proposal is heartless and it's tone deaf. Now, I welcome you spoke to religious institutions, but you need to speak to the pharmaceutical companies involved and demand that they too pay for the pain and suffering that they caused. Forced adoptions, forced labour, physical and sexual abuse and vaccine trials happened in these institutions, and they should all be held to account along with the state. It's a dark stain on this state's history. Now, Minister, you need to listen to the criticism of this scheme and make the changes that is needed for it to be acceptable for survivors.
Minister, we wouldn't be here this evening if you use the findings of the Oak consultation with the survivors of the mother and baby homes. Nobody wants to be here, and least of all the people who are watching in tonight. The survivors don't want to be watching into this, and I send them our solidarity. And I thank each and every one of them who has engaged with all of us across the House and told us their stories. And some of them tonight, even watching, there's a couple of things that they have risen with me since this debate started. You say you aim to seek consensus over division when you talk about the House here. But they are asking, why are you continuously trying to create a divide within survivors? You really need to hear that going out of this chamber here tonight, and you need to include it in the legislation that you're bringing forward. You also say that the government went significantly further when you refer to what the government has done, and they say it's not far enough. And if they say it's not far enough, it's not far enough, Minister. They also, you say about it being the largest scheme of its kind in the history of the state. But they want to remind you that it's also the largest scandal, the largest and most inhumane scandal in the history of the state. So you have to listen, Minister, even at this late stage. I want to remember tonight the tenacity and courage of Catherine Corliss as well in uncovering the scandal of the 796 babies still in the sewage tanks in Tuam, 208 of them from my own county of Mayo. And I want to acknowledge the recent initiatives by Valerie Jennings and Joseph Mulcrone to highlight that to you, and that needs to be done. Minister, please listen to the survivors.
Minister, there's countless men and women living in my area who have a history intertwined with the Casa Pollard institution, and I don't have the time to fully express to you the hurt and frustration and disbelief that they have expressed to me. But what I do want to do is place on the record of the Dáil quotes from the open letter written by the survivors of the Casa Pollard institution earlier this year. And it begins, "The sad fact is that losing a baby to forced adoption is a traumatic event in any mother's life, causing a form of post-traumatic stress disorder, and it makes zero difference as how soon after birth this trauma is inflicted. The horror remains, the depression, anxiety, nightmares and flashbacks. The Commission's final report is deeply flawed. Up to 15,000 people were illegally adopted during the time frame under investigation, and they are excluded. They've spent their entire lives giving false, misleading and potentially lethal family medical histories to doctors and hospital staff. Furthermore, the rest of the county homes were ignored by this Commission. More than 24 escaped investigation. Where is their truth and justice? We listened to the Taoiseach and Taoiseach apologise in the Dáil today. Neither mentioned their own political parties nor their culpability in what is essentially Ireland's own little Holocaust. Insult headed upon injury and salt thrown in the wounds by the empty seats. Apparently, it was society's fault. What was the point in our testifying if the word was to be doubted? Our testimonies are the proof. Neither of this sickening double act in the Dáil today bothered to tell the real and immediate action for living survivors. The living survivor community must take priority. We need action while some of us are alive. Minister, these are the raw, hurt words of survivors, told in their own words in an open letter. They have had enough of political waffle to last them more than a lifetime. They have been failed time and time again. Actions, not words, is what's needed now, because people start to heal the moment that they feel heard, and these survivors have yet to feel heard. Don't deny them. Again, Minister, don't let it be on your watch. Ensure that justice is finally delivered.
Thanks very much, Cathaoirleach. First of all, I want to thank everybody who is involved in the debate. I also welcome the fact that the motion isn't being opposed. Genuinely, I think, Ministers, you've heard tonight that people do want to work constructively. And I think that is why we brought this motion forward, to highlight the issues. Everybody, and I imagine it was the same for government TDs, that you were inundated as well with people asking why they were excluded from the scheme. Nobody, I don't believe that anybody, no matter whether you're stand in opposition or government, wants to exclude anybody. So that's why we brought the motion forward. And I genuinely hope that there's sincerity when you say you want to work with us and you're not opposing the motion for that reason, because everybody wants a scheme that will suit and that's fit for purpose. And as I said earlier, this has to be the Dáil that finally deals with the issues, because we've been talking about them for so long and people are literally dying as we're debating them. And I do want to reiterate what I said earlier, Minister, that I know a lot of this was left at your door by predecessors that were probably happy enough to leave it there. But you do now have, in a way, an opportunity to actually deal with it properly and constructively and listen to people. The letter was mentioned, the letter that was written to yourself on a number of occasions. And I do want to just read out, some of it was already read out, but I want to just read out these final 2 points. And I think that we should welcome that we have such experts that we can look to, particularly when this does come for the legislation and the pre-leg process. I'm hoping that people like this will feed into that and that we can base this on some of their work. And I think it's excellent, as Deputy Connolly said, that they actually had the courage to come out with this at the weekend. So they say we are seeking a revision of the recommendations arising from the report with inclusion of best practice guidelines regarding neuroscience, childhood trauma and attachment. We are willing to work alongside you to see these changes through and want to meaningfully contribute to better practices rather than simply criticism from the sidelines. One final point, these women and children have experienced complex trauma and adversity in their lives. Yes, the money will help, there's no doubt about it, but there is also an opportunity to right a wrong, to empathise at a human level and seek to understand. We want to minimise the risk of secondary traumatisation and invalidation of survivors and their families, which is most likely where experiences are not heard, respected and redressed. Fundamentally, it is about mothers, children and families being seen, heard and having their lived experiences validated. Collectively, we can surely strive for this. And I think that perfectly sums up what is trying to be achieved by this motion. And this is, it's obviously, these are people who are clinical psychologists, therapeutic social workers. They're obviously working with children and understand trauma very well. And I do think we should take their suggestions on board, although I think everybody would agree this has to be inclusive. It should include all survivors, and particularly around the medical card aspect, because an awful lot of women are re-traumatised by that they were really holding out and waiting for this enhanced medical card, and it's not right that they would be denied it. And I just want to reiterate in relation to interim payments, I do think that's something that should be looked at, and it is being examined in the 6 counties in relation to their report. So again, I just reiterate that I believe there's statements again Thursday on this, so we'll be discussing the topic again. Then I want to thank people for their support in relation to this, and I just want to, I suppose, send solidarity and support to all survivors that were sent to institutions, anybody that was born, their families, because I know that this re-traumatises them every time we talk about it, but it is important to raise the issues as well. And I just, I'm thinking of all of those people that I've met and that we all have met as well. So thanks very much, Cahill.
Thank you, Deputy.